Welcome to the Labor and Employment podcast series. This podcast will address Transgender Employees by Langdon Ramsburg, attorney at law. Mr. Ramsburg practices in the labor and employment, public sector, and white-collar defense and internal investigation groups at McNees.
Recently, more and more employers are being confronted with the question of what to do after a transgender employee gives notice that he or she intends to transition to a different sex. It's a difficult question with a constantly evolving answer. The first thing employers need to know is that transgender status is very likely a protected trait under both federal and Pennsylvania law, meaning an employee's transgender status cannot be the basis for an employer's adverse employment action. Here's the rationale. Title VII of the Civil Rights Act of 1964, as well as the Pennsylvania Human Relations Act, prohibit employers from taking adverse employment action on the basis of an employee's sex. In 1989, the Supreme Court of the United States issued an opinion in a case called Price Waterhouse v. Hopkins. In that case, a female employee was denied a promotion to partnership in an accounting firm because she did not act in a way that the firm believed a female employee should act. In the firm's view, she needed to act more feminine. The Supreme Court held that making employment decisions based on an employee's failure to adhere to gender stereotypes is discrimination on the basis of sex. Taking the Price Waterhouse ruling and applying it to transgender employees, the Equal Employment Opportunity Commission, the Pennsylvania Human Relations Commission, and several federal appellate courts have all concluded that employment decisions based on an employee's transgender status is discrimination based on the employee's failure to adhere to gender stereotypes. So, Attorney General Sessions' recent memorandum suggesting that transgender status is not a protected trait under Title VII is belied by a substantial body of law to the contrary. There's also an emerging line of thought that transgender status is protected under the Americans with Disabilities Act. Gender dysphoria is a mental disorder recognized by the American Psychiatric Association in which a person experiences distress because of the sex and gender assigned at birth. Therefore, taking employment action on the basis of transgender status may be discrimination on the basis of a disability, which is prohibited by the ADA. So recognizing that transgender status is likely protected by federal and state law, an employer cannot simply bury its head in the sand when an employee transitions between sexes. But what exactly should an employer do? Here are some best practices. 1. Consider enacting a policy regardless of whether you suspect an employee may or may not be transgendered. The policy should invite, but not require, employees to notify their employer in advance of their intended transition. The policy should indicate that any notice of transition will be held in strict confidence. 2. After receiving notice, the employer should engage in an interactive planning process with the employee. The planning should contemplate things such as name changes, bathroom use, date of anticipated transition, and need for leave. 3. When the employee is ready to make the transition public, the employer and employee should issue a joint statement to the employee's coworkers. The statement should notify the coworkers of what to expect and be reminded that harassment will not be tolerated. And finally, 4, the policy and planning should specify a complaint procedure that the employee can use to report any harassment. But the employee should understand that there must be a reasonable period of time for coworkers to adjust. So while the employee can make a complaint of harassment at any time, the employee should expect a period of time after the announcement during which coworkers will, as a matter of habit, refer to the employee as his or her prior name and use pronouns consistent with his or her prior sex. For more information on this topic, please stay tuned for an upcoming webinar where we will discuss in depth each of these best practices.